Well, there are at least a couple of pretty significant challenges that we face because of the way the statutes are written. The first is really, even under the Shepard-Byrd Act, which has the broadest protections in terms of statuses, it includes, of course, sexual orientation, gender identity, and gender, is that when the offense is based on one of those perceived or actual statuses, we also have to prove that the crime affected interstate commerce, meaning that there was some use of an instrument of interstate commerce, like a phone or a computer, access to the internet, where there were those wire transmissions that caused the cross-state lines, or there was an effect on interstate activity or economic activity. Maybe the offense occurred at a store or had an impact on that store's ability to do business, or if there was some transportation involved across state lines. But having that extra element of proving interstate commerce can be a little bit cumbersome. Okay. The reason that we have to prove that is because Congress only has the authority to act where the United States Constitution gives them the authority to act. So there has to be some basis in Article 1 of the Constitution for Congress to pass that legislation. And for federal criminal law, oftentimes that is the Commerce Clause that provides that authority. If under the Shepard-Byrd Act, if there is a crime that's based on race, color, or national origin, we don't have to prove interstate commerce, because in that circumstance, Congress can act based on its authority under the 13th Amendment, which outlawed slavery. And then in the second part of that, the second clause basically says, Congress, you have the authority to do whatever is necessary to affect this end to enslaving people. And so that part of the Constitution has been used over and over again by Congress when it has acted hate crimes legislation based on race, prohibiting conduct based on race. The second real challenge that we have with the statutes is that we have to prove that the offense occurred because of the protected status of the victim, or because of the person's race or color or national origin or sexual orientation, gender identity, whatever. And what that basically means is that the offense would not have occurred but for the protected status of the victim. And oftentimes cases, the facts may be complicated. There may be other possible motives, there may be dual motives, but we have to have that higher burden to show that, when push came to shove, the crime would not have occurred but for the protected status. And that really is an impact that only came around in the last couple of years because of a Supreme Court case that the lower courts have interpreted to apply to hate crimes cases. And then really the third challenge is that oftentimes the victims don't know, the perpetrators don't know the suspects in the crime, because the victims are selected randomly because of their protected status, whether it's race, color, national origin, sexual orientation, and because someone may have seen them walking down the street, going in and out of an establishment, and picked them because of what they thought about their race or color, their sexual orientation. And so the victims often cannot help law enforcement identify the perpetrator.